Parag Amin. I'm an attorney, and my office and I help business owners successfully navigate challenging disputes and protect their business, livelihood, and legacy. The reason I started this podcast is I don't believe there's enough education and enough information for entrepreneurs about the potential legal issues that could destroy their business. So I wanted to put this information out there. I wanted to make it more accessible, and I want you and your business to thrive. The reason I wanted to do any of this, the reason I became a lawyer in the first place, is because my dad, who's an immigrant from India, had taken his life savings and invested it in this store in Florida. I remember moving from New York to Florida because my dad had taken everything he had and invested it in this business because he believed that entrepreneurship is the American dream. So he moved my family to Florida, and I remember him and my mom would be working 60, 70, 80 hours a week trying to get this business to be successful. And after toiling away and working hard for a couple years, the taxing authority from Florida came knocking and told him that he owes over $200,000 in unpaid sales taxes. My dad said, there has to be some kind of mistake. We don't even make that kind of money here at the store. You have to have made some kind of error. There's no way we could owe that much in unpaid sales taxes. What my dad didn't know is that when he had purchased the entity that owned the store from the former business owner, he had bought all the liabilities with it. And what he also didn't know, and that the former owner had not disclosed to him, is he hadn't paid his sales taxes. So now the Florida Taxing Authority didn't care. They said, look, you owe us the money. You've got two options. One, either pay us what you owe us, or two, shut down your business. And facing that huge liability, the calculations and the financials just didn't make sense for my dad to keep going. So he made the tough decision to shut down the store that he had put his life savings into. And after that, he tried to find his footing by finding another business, but he just couldn't find the right thing. And because he had a young family to support, he ended up getting a W-2 job. And he ended up losing his dream of becoming an entrepreneur. So that taught me at an early age that entrepreneurship and the right legal representation go hand in hand. Had my dad just had the right advice, had he just had the right guidance, I think he would have been able to survive this or even prevent it. And that's why I went on to law school, is because I didn't want that to happen to somebody I cared about, somebody I loved, or to other business owners. So I went on to get my law degree from the University of Southern California, and I started my practice a couple years after graduating. And the intention has always been to help business owners successfully navigate challenging disputes or issues that can destroy their business. Today, I want to talk about 3 big ideas that can help you in your business avoid some of the challenges that I see. The first issue I want to talk about is agreements. Making sure you have your agreements in writing and making sure that they're accurate. A lot of business owners will get the first part right and they'll have their agreements in writing. But the second part I see time and time again being a huge mistake with business owners. Many times business owners are used to doing handshake deals or having conversations, and they're big picture people. They're not necessarily involved in all of the intricate details. And one of those intricate details is making sure that the agreement is in writing and is accurate. So what happens is business owners will discuss something with somebody else and have a handshake deal about it. And they might even have a written agreement, but the written agreement doesn't actually accurately reflect what they had discussed and what they had agreed on. So what happens in that situation is when there's a dispute or a lawsuit, everybody goes back to the contract. And then there becomes a dispute about the contract not being accurate. And unfortunately, when you're a business owner, you're automatically assumed to be sophisticated, regardless of whether you're sophisticated or not. It doesn't matter if you have a tremendous amount of experience or if this is literally the first day of your business that you entered into this agreement and it doesn't accurately reflect what you thought it was supposed to reflect or what you thought the agreement was. So you want to make sure you have your agreements in writing and that they're detailed and accurate, because most agreements will have something known as the integration clause. The integration clause says that this is a full and accurate representation of what the agreement actually was. It also says that it supersedes any and all prior discussions or written agreements. So when you get into a dispute and you try to say, well, this isn't actually the agreement, we had discussed something else, we had agreed on something else, the other side's going to come back to that exact clause and say, look, not only is it not in writing, but you agreed that this writing that we're all looking at is the full and final agreement. So do yourself a huge favor. Make sure you're paying attention to the details. Make sure that you're getting your agreements in writing and that they're accurate. Don't let somebody tell you that it's not a big deal. Oh, there's a provision of this agreement that we don't normally enforce anyways. It's fine. Go ahead and sign it so we can get this deal done. Those kinds of things can and will come back to haunt you later. My office has dealt with, at this point, hundreds and hundreds of lawsuits and disputes, probably into at least 1,000, if not thousands. And one of the things that commonly occurs is the thing I'm warning you about right now. And that takes a lot of time, money, and energy to sort through, because then it becomes an argument about a he said, she said. And that's what the integration clause is there to prevent, is an argument about a he said, she said, and a disagreement about what the actual agreement was. Because if it's not in the agreement, it's not a part of the agreement. I'll give you an example. I represented a sophisticated business owner who had gotten into an agreement with an ex-romantic partner of his. They'd gotten into this real estate deal. He had signed a promissory note saying that he was going to repay her $275,000 plus interest plus her attorney's fees if he didn't repay it. So that agreement was drafted by her counsel. He thought it was wise to simply handle it on his own because he had years of business experience. And at that point, they were in a relationship that was going well. He never thought anything would come of it. And he thought that the business relationship would continue on and be prosperous. She wanted this agreement in writing, even though he said that the agreement was that they had invested in a property together, meaning they were both bearing the risk of loss, that this was not supposed to be a promise of repayment by him to her, but instead they had both invested in this business together, in this property together, and if it was successful, they would share the profits. But unfortunately, what neither of them expected to happen happened, and the property was ultimately sold at a foreclosure sale, and they lost their investment. So what did the ex-romantic partner do? And at that point, she had become an ex-romantic partner. She sued him on the unpaid promissory note. The promissory note was notarized. There was no doubting that it was my client's signature. My client had admitted it's his signature. So the issue is just the black and white terms of the promissory note, where at that point, his exposure exceeded over $500,000 because he had unpaid interest, he had unpaid principal, and he also had to pay potentially the other side's attorney's fees if he lost on what was a black and white agreement. He hired my firm to help him navigate through this crisis and issue. Ultimately, the other side kept coming back to the same problems I'm telling you and warning you about right now, which is the agreement is black and white. It's notarized. There's nothing in there about an investment between them together. Look, luckily my office and I were able to successfully navigate this for the client. We got him off of a payment plan over 18 months for paying about $49,500, split evenly over 18 payments. And we had made a motion to make sure that that was enforced, that we won. So we were able to get our client out for a fraction, less than 10% of what was owed or would have been owed had he lost the agreement. Ultimately, the issue there was the other side didn't want to go to trial. They knew that we'd do well at trial, and they chose to settle out the agreement, but it was a risky maneuver for my client that could have cost him a lot of money if he had lost. So make sure that you have your agreements in writing, that they're accurate, because regardless of how good the relationship is right now, it might very well sour in the future. And there may be a reason you have to go back to the agreement. And if the agreement isn't accurate, it could be very, very problematic for you. Now, the second thing I want to warn you all about is partnerships and getting into partnerships. You want to make sure that whoever you're getting into a partnership with has the right attributes and work ethic before you get into that partnership. And of course, make sure you have your partnership agreement in writing. This will include things such as making sure that you have a written list of rights and obligations that you each have to the business and to each other. Some of the things you want to think through with counsel are: what happens if one of you unfortunately passes away or one of you no longer wants to be in the business? What happens to that partner's ownership interests? Can they simply sell it to whoever they want? Can they simply transfer it to whoever they want? Because remember, if you're a business partner with this person and they transfer the ownership, you might end up in a partnership with somebody you don't even know, or possibly somebody you don't want to be in a partnership with. So you have to be very, very careful about how you lay this out. Another example is, if everything's going well, how and when are profits supposed to be dispersed or distributed? You may have one partner who wants to reinvest any and all profits back into the business, and you may have another partner who wants to take profits out of the business. Remember, if you do have profits in the business, you are probably going to have a tax bill regardless of whether you choose to reinvest in the business. Now, of course, talk to your tax attorney about this, but generally speaking, you're going to have a tax bill if you have a profit, regardless of whether you choose to reinvest it. So you could be in a situation where one partner wants to reinvest all of the profits into the business, while you've still got a tax bill to pay, which means that you've got negative cash flow, which could be potentially problematic for you depending on your cash flow situation and your other financial obligations. So this is just a simple example to help you think through how you want to handle things such as money, whether either side has to put more money in if the business isn't doing well. That's another thing that could affect your financial obligations and position outside of the partnership. If you have other businesses, you also want to consider if you're allowed to start a competing business, or if your partner is allowed to start a competing business, or whether either one of you has to put in a minimum number of hours into the partnership to help make sure that the partnership's business is successful. You also want to think about whether either of the partners is supposed to draw a salary, and if so, how, when, whether that needs unanimous approval for the purposes of increasing or decreasing somebody's salary. As you can imagine, this can get very complex, and there's a potentially endless list of questions, but there are the really important questions. It goes down to the 80-20 rule, where 80% of your problems will come from 20% of the things that you had not thought through. So you want to make sure that you've got counsel helping you think through at least the major issues, if not a significant portion of the problems that are going to cause you potential issues, because those are the things that end up costing you a lot of time and money. Now, the third thing that you want to make sure that you've got is being prepared for a lawsuit. I'd like to go back for a moment and give you an example of a partnership dispute before we jump to the third issue of being prepared for a lawsuit. Partnerships. I represented a partner in a partnership dispute where her and her ex-romantic partner had also gotten into a business relationship together. They had invested in real estate, and they simply hadn't thought through the issues, and instead they thought they were thinking through the issues by getting their partnership agreement off LegalZoom. LegalZoom can be great for some things, but when you're thinking through a partnership that's going to have any substantive value whatsoever, it's probably not going to be the right choice, because it doesn't think through the major issues for you, and it doesn't help guide you through most of the issues that can potentially cost you a lot of money. So in this example with the partners, they had gotten into a partnership agreement over the real estate using LegalZoom, and one of the partners had put in a substantial amount of the capital, whereas the other partner was doing more of the day-to-day work on the partnership. But all it said is that they're both 50-50 owners of this partnership. And when the romantic relationship fell apart and there were disagreements about whether each side was doing what they were supposed to do, there was a huge disagreement and finger pointing back and forth that the other side, the other partner, wasn't doing what they had agreed to do, and they shouldn't get 50% of the partnership. So inevitably, this case went into litigation, meaning a lawsuit. We litigated for months. Ultimately, my office and I were able to successfully resolve this case favorably for my client. She walked away with millions more from the real estate deal than her ex-partner because of some creative things we were able to use in resolving her case and some creative arguments we were able to make about how the other side simply hadn't done what they were supposed to do and how it cost the partnership money. But getting to that point also took more time and money. So you want to make sure that you are thinking through the partnership agreements. Now, luckily, in the case that I just told you about, we were able to get the client multiples of what she had paid, many multiples of what she had paid in attorney's fees as a resolution. But remember, these kinds of things are many times zero sum. So the other side ended up losing millions of dollars that they might have otherwise been entitled to, all because of an improperly drafted, poorly drafted partnership agreement. So make sure you've got your partnership agreements thought through. Do this before a dispute arises, before a problem arises, because problems are much easier to resolve when they're hypothetical rather than actual. Things are much less emotional when you're thinking through a problem before it's actually affecting somebody's bottom line and it's affecting their livelihood. So think through it, save yourself a bunch of time, money, and headaches by having the right representation ahead of time. Now, the third point I wanted to talk about is being prepared for a lawsuit. Look, I know that no business owner wants to go through a lawsuit. Whether you're on the plaintiff side, meaning the one filing the lawsuit, or on the defense side, meaning you're the one who's being sued, it isn't typically what you wanted to do. You see it more as a last resort than something as a first choice. Inevitably, lawsuits will arise. Regardless of how small or big your business is, if you're in business long enough, unfortunately, you are going to be involved in a lawsuit. So you just want to make sure you're best prepared for that lawsuit. Now, you may be wondering how you do that. It's great that you tuned in because I'm going to tell you exactly how you remain well prepared for the inevitable lawsuit. First thing, as we talked about earlier, make sure you've got your agreements in writing. Make sure they're well documented. Make sure that they're accurate about what the true agreement is. Document as much as you can. Documentation is king when it comes to lawsuits. Having things in writing is 10 times better than having some kind of verbal agreement. Because look, in most cases, although verbal agreements are just as enforceable as written agreements, the problem arises when it's just a verbal agreement without anything in writing or with very little in writing. Memories differ and memories fade about what the actual agreement was. So because a verbal agreement is much more susceptible to a he said, she said argument, it seems much more subjective than a written agreement. Written agreements and written documentation about even conversations you've had regarding agreements or regarding certain deals will do you a huge service if you're ever involved in a lawsuit. Also, when it comes to written documentation, it doesn't always have to be some formal legal document. You can send confirming emails, something as simple as, hi, just confirming our phone conversation earlier today that, and then recapping what you discussed. Now, here's a quick tip and trick for you. End that email by saying, please let me know by no later than blank if any of the above is inaccurate. This is subtle, but a huge difference between saying, please let me know if any of the above is inaccurate, along with a specific deadline, versus saying, please confirm. Because if you think about the modern business environment, we all get hundreds of emails a day. And it's very easy for an email to get buried, and it's very likely you will not get a reply to your email. So when you write, please confirm, and they don't send you back the confirming email, and you forget to confirm, now you've got an email where they're going to say if there's a dispute, well, you said, please confirm, and I never confirmed because it wasn't accurate. Now, when you flip that and you say, look, please let me know if any of the above is inaccurate by blank date, and they don't get back to you by that date, or they don't get back to you at all, now you've got a much stronger argument to say, look, not only do we have this discussion, but I documented it in writing, and I told them to let me know if any of the above was inaccurate, and they never sent me an email. So surely it was accurate. That one tip alone can save you a lot of time, money, and headaches. So make sure you use it. Another key component is organization. Having your files organized and easy to find is going to be critical when it comes to a lawsuit. Now, the one thing everybody knows about legal representation is it's not cheap. Now, think about how much more expensive legal representation gets if your documentation isn't organized, isn't put together well, and your lawyer or the paralegals have to go searching for documents and have to spend time organizing the documentation. It's going to cost you a lot more time and money, and it's also going to slow down the legal representation. So do yourself a favor by organizing it ahead of time. Some simple tips are electronic organization of your files by creating folders. You can create folders with the types of documents that are going to be in there. For example, you could have one folder titled contracts. You could have another folder titled text messages. You could have another folder titled emails. And you could drag and drop and put all of that into the electronic folder. This will not only make it much easier to organize, but it'll also make it much easier for you to be able to share the information with your counsel so they can easily find out what's going on and easily find the relevant document or documents that pertain to your case. The other added benefit of digitized documents and electronic documents is you can more easily search through those documents. So if you're looking for a specific term or terms, if you're looking for a specific date, or you're trying to organize the documents in different chronological order, depending on what you need, that will be much easier if you do it electronically than if you do it with a physical binder or a physical box full of printed papers. Imagine how much longer it's going to take for somebody to transport and sort through written documents and to search for that one document, the needle in a haystack in all of the documents you have. So take advantage of modern technology. Make sure you're digitizing your documents. If you want a quality scanner that can digitize written documents that you don't have electronically, and you want a document scanner that can do it easily and quickly, you can pick up a Fujitsu ScanSnap scanner. I do not get any kind of affiliate revenue for saying that. I am saying that simply because I have used it for years, and it is the best I have found on the market as far as a scanner goes that isn't a large scanner, that's very portable, that can make scanning hundreds or even thousands of documents a breeze. This will be one of your best friends if you have a lot of written documentation that's physical, but it's not digitized. The other thing you want to think through as you're looking through documents and finding documents and having written documentation is being careful about who has access to all of these documents. If you simply let any and everybody access any and all documents, you could have a major problem if it comes to somebody improperly using your information, because you have various problems that can occur by claiming that this person was improperly using trade secrets or confidential information when you're not treating your own information as confidential. So if you're in California, you might risk a situation where an employee or an ex-employee starts a competing business by using your confidential information, and you weren't treating the information as confidential. And so you're going to have an even steeper uphill battle trying to say that this ex-employee was using your confidential information if you're not treating that information as confidential. So treat information ideally on a as needed basis. Don't provide complete access to everybody at your business to any and all information. Now, of course, the more confidential the information, the fewer the people that should have access to it. You want to make sure that it's segregated from the other data. Ideally, it's password protected, that not everybody has access to, because this is going to be a key question if you have litigation or a dispute later about somebody improperly using your trade secrets or improperly creating a business that unfairly competes with you and your business. Those are the three components, big ideas that I wanted to talk about today. As a part of this podcast, I am going to be providing a lot more data, a lot more information. So please subscribe so that way you know when the new podcast drops. Also, if you're interested in being a guest on this podcast, talking about your business, talking about how you've successfully navigated crises in your own business or legal challenges or problems in your business, we'd love to have you on. I will include information below in the description so that you can click the link and apply to be a guest on my podcast. Thank you so much for joining me. My name is Parag Amin, and I'm looking forward to seeing you next time.